As we all know, Right to Information Act was one act which was enacted in the year 2005. And for the last couple of years, we have been celebrating the period from 5th of October till 12th of October as a week for right to information. There are celebrations, seminars, conferences, awareness campaigns that are taken across the nook and corner of the state, highlighting the importance, aim and object of the Right to Information Act. But what we all need to also understand is what led to the enactment of this Act of 2005. If we ponder the library or go down into the Google and search, and we will find that this campaign in fact had started long back, much earlier to 2005 when the Act was enacted. As per the researches, one of the earliest informations that was sought was when the election of the then Prime Minister, Srimati Indira Gandhi, was challenged by Shri Rajnarayan. There was informations collected so far as the alleged electoral malpractice is concerned. This was in 1975. Subsequently, in 1982, there was an unrest within the judiciary so far as certain transfers that were made. Then came a judgment of the Honorable Supreme Court in the case of S.P. Gupta, 1982, which also laid down the foundation so far as obtaining informations which had led to the grievance of the petitioners therein. Thereafter, there was silence for some times, but in 1995, in the state of Rajasthan, there was a massive agitation among the Kisans over there. It so happened that there was a great famine that took place, and after the famine, to support the farmers, the government introduced the employment projects, providing employment to the farmers to pay them the salary so that they can sustain. But a few of the people noticed that at the end of the day, when the salaries were being distributed, the people who were toiling in the sun, sweating, were paid less, and people who were buttering the officers never entered into the field, not even worked even for a minute, were paid more. And then they found that it was all a mischief that was being played in the muster roll. Then this led to the information that was sought, and it was found that there was irregularities being committed by the officers in the maintaining of the muster roll, so that their chosen people were paid more and the people who were in fact working hard were paid less. And all this gradually developed, and finally in 2005 this Act of 2005 was enacted. It is in fact a vital democratic instrument meant for the effective governance, transparency and also institutional accountability. The Act empowers citizens to seek information and compels the public authorities to operate with openness and with great integrity. It is one of the most empowering legislations that India has enacted in the recent past and has allowed the citizens to receive meaningful participation in the democratic system. Information commissions, PIOs, the appellate agencies have been established so that the information seeker is provided the necessary information disclosing the workings and the implementations of the scheme of the government being known to the public as well. But we all know that there are a section of people who have down the line tried to misuse the provisions of law and have also taken this act as a profession in obtaining information and then misusing the same for the purpose of extortion and many other things. It is such people who we need to tackle sternly, but at the same time, a genuine information seeker should not be deprived of the information which can help him either for the betterment of his or for his legitimate claims that he may have. Maybe if it is an employee in respect of his pension, maybe in respect of any of his retirement dues or service, if he is still in service, for any of his service dues that he is entitled for, maybe promotion, seniority, and so on and so forth. It is expected that a public authority shall disclose all information held by him related to the welfare schemes floated by the government and which is implemented for the betterment of the general public. Various mechanisms have to be derived. I'm not sure whether we have, but many states do have an online platform for obtaining this information, which has made things very easy, very transparent, and the commissions and the authorities do not require large manpower at their disposal for the providing of these informations. The framers of this act had conscientiously decided to have it for the utilization of the citizens, which would lead to more transparency and accountability, which in turn would result in betterment of all the sectors and above all reduce the scope of corruption. When we celebrate this week, 5th of October to 12th of October, as a week for under the right to information, what is required more is that we should make the general public the last man in the queue, that he has this provision of law which he should make best use of in getting informations with which the life of that citizen or the last man could be made better. As we celebrate this week, some of the key aspects that is required to be known is the purpose for which this act was enacted, that was to provide a practical regime for the citizens to secure access to information under the control of the public authorities. 2, the goal for which this act was enacted, that was to promote transparency and accountability in the functioning of the public bodies. 3, who is covered under the act? The act is applicable upon every citizen of this country and particularly the state. 4th, what is the information that has to be provided? It encompasses various or any sort of material in any form, including records, documents, emails, reports, data in electronic forms, and information relating to private bodies that the public authority has an access to. And lastly, what is the right to information? It includes a right to inspect a work, right to inspect a document, a right to obtain copy of the records maintained in respect of the same. It is in respect of taking notes, extracts, certified copies of these relevant documents which could be beneficial for the information seeker. Why this act is important for the general public? There are 3 things. One is it empowers the citizen. An informed citizenry can better monitor the government activities and hold it accountable. It ensures accountability. This act makes the government and its agencies, particularly the public authorities, responsible for their act and actions and also the decisions that they take. And lastly, it strengthens the democracy. By increasing the access of information, the act reinforces the democratic principles and the citizens' participation in the democratic setup of this country. To conclude, I would only say that the right to information is not just a law. It is a symbol of participatory democracy. It reminds the government that they are answerable to the public. It gives voice to the voiceless people, power to the powerless, and courage to the common man to question those in power. As a citizen, we must understand and promote such rights to the remotest corner of this state. We must use them not just for the personal benefit, but also for the betterment of the society. Let us all remember the words of Wajah Habibullah, who says that RTI is not about information, it is about justice.